My name is Archana. I'm your educator for Indian Polity. Today we are going to discuss about the leftover topics of salient features of Indian Constitution as well as the other chapter called as Preamble. Okay, so we are going to discuss about two topics. Again, I say we are going to continue the leftover part of salient features of Indian Constitution and as well as Preamble. So let's start the lesson. So, in the previous class, we have discussed the major features, salient features of Indian Constitution. Like Indian Constitution is the lengthiest written constitution in the world. We discussed that it is neither rigid nor flexible. We also understood that a parliamentary form of democracy is being adopted. We have, we have borrowed the various features from other constitutions. We didn't discuss that in detail, but we understood that various features have been borrowed, and we have emergency provisions. We do follow three-tier structure. We have a single citizenship. Like we have discussed many salient features or the unique characteristics of Indian Constitution. And today in this chapter, we are going to discuss about the major sources of Indian Constitution. Very, very, very important part. This area is a very good area for people who are writing other examinations like SSE, banking, or other examinations except for UPSC. UPSC it is for more of understanding, but for other examinations, you have a good number of chances to get questions from this particular area that is called as major sources of Indian Constitution. So let's start the lesson. See, we do have many sources of the Indian Constitution, but out of them all, the most important the first and foremost source for the Indian Constitution is Government of India Act 1935. It is the first source of Indian Constitution, and it is called as Mother of Indian Constitution. It is called as Mother of Indian Constitution because the important characteristics have been borrowed from this Government of India Act 1935 only. The first and foremost or major one is being the federal scheme. When I say federal scheme, you need to understand that the presence of state as well under union is nothing but the federal characteristic. The second feature is emergency provisions, like when things are out of control, when you feel that the law and order or when you have any unforeseen situation or emergency or a war condition, you need to immediately make sure that the people are in control. You have to take control of the whole country, and that is nothing but the emergency provisions. And we all knew that emergency provisions are of three types. We have national emergency, we have a presidential rule, and also we have financial emergency, which we have taken from Government of India Act 1935. The third one is public service commissions. We knew that we have UPSC, SPSC, that is State Public Service Commissions, and JPSC, that is Joint Public Service Commissions. This concept is being again borrowed from Government of India Act 1935. The office of governor. Yes, we all knew that governor is a representative of president, and since president cannot monitor each and every state at the ground level, it is not possible for him. He will appoint his representative, that is nothing but the governor, and this concept of governor is also being taken from Government of India Act 1935. The judiciary. Judiciary is an important organ for the government, and the main purpose of the judiciary is to look after the constitution, to make sure that the constitution is being safeguarded. When I say safeguarded, is not about protecting, but making sure it is being implemented thoroughly. It is being implemented thoroughly in the country. That would be protected by this judiciary. And other administrative details are also being taken by Government of India Act 1935. And so the first major primary source for Indian Constitution is nothing but Government of India Act 1935, or which is also called as Mother of Indian Constitution. The second major source for borrowing the features, like from where we have borrowed the constitution, is the British Constitution or law. However, we do have certain exemptions or limitations, like as long as you're a prime minister, you will not be called for any of that. You will not be treated equal to other people because you'll have that privileges, right? And as a president also, we do have some privileges. But once you're out of that position, you will be treated equally with every other person. That is the reason our ex-Prime Minister, Mr. Manmohan Singh, he was called by CBI for an inquiry about the scams that happened after he was out of his Prime Minister post, not when he was in Prime Minister post. So once he's out of that position, he is being treated equal to everyone. That is nothing but called as rule of law. And also equal protection of law means we have to make sure that law is the same, law is the same in equal conditions. In any equal condition, the law should be same. You cannot violate it. You should not see the end result of any violation. You have to see the circumstances that led for the violation, and based on that circumstances, a decision need to be taken in the court of law, and that the decision should be equal in equal conditions. This is a very deep in thought example. I'll give you one example for equal protection of law. See, men and women, a woman has killed a man, in protecting her dignity, and as a process of her self defense, she killed a man as part of her self defense. Now the consequences, the person is dead. Okay, the person is dead, and it is a clear cut death of the person. The consequence is death only. Now you cannot treat this death equivalent to a planned murder. So protecting as person protecting themselves as part of self defense cannot be equivalent, cannot be made equivalent to a murder. So murder is different scenario, self defense is a different scenario. All those people who are undergoing, who have gone for that self defense, they should be treated equal. All those people who have murdered, they should be treated equal. You cannot compare both of them, because ultimate result of these two scenarios is death only. So you cannot just link that. That is nothing but called as rule of law. And the next one is you have writs. Writs are nothing but extrajudicial tools available for the people. If in case, like, if they are not able to ensure justice in other conditions, to ensure that justice, extrajudicial tools we have nothing but writs. And the beauty is you can file these writs both in Supreme Court as well as High Court. In Supreme Court, you can file this writs under Article 32, and in High Court, you can file this under Articles 226. Okay, so you have the power to approach either Supreme Court or High Court with regard for extrajudicial justice. When, if in case you are not able to get justice in normal conditions, you have this power, the ultimate power called as the writs under Article 32 and Article 226 for High Court. And the concept of speaker and the role of speaker. See, speaker plays a very important role in the parliamentary affairs. Now, he is the head for the Lok Sabha. The best power is, the best beauty of the speaker is he is the ultimate man. The speaker is the ultimate person to decide whether a bill is a money bill or not. You have to understand this. So, he is the main person. The speaker is the main person who will decide whether a bill is money bill or not, and based on his decision and whatever decision he's taken, that need to be followed. So speaker, it seems like more like a class leader. The speaker seems to be more like a class leader, but no, it is a very powerful post we have, and he will be taking care of all the parliamentary affairs happening in the Lok Sabha. He will have the power to suspend a person from the meetings, from the Lok Sabha sessions. He will have the power to suspend a person from his post if in case he is violating, if he is going for any defection, or going against his party, the member if is going against his party. All this is vested with the speaker, and he is the tiebreaker. When opposition and ruling party are stuck with equal number of votes, like when a bill need to be passed, and regarding the passing of the bill, when both the opposition and the ruling party are stuck with the votes are there equally with equal votes, then the person who is the tiebreaker is nothing but the speaker. He will cast his vote not in general conditions, only when there is a tie he will use his vote. That is the power of speaker. So the best power, the most important power of the speaker is he is the man who will decide. He is the man or the woman who will decide whether a bill is money bill or not. And also how to make laws. The law making process is also being taken from British. Like how we are going to make a law, we'll write a draft, we will present it to the cabinet, and then the discussions they will send it to president, and from the president it will come to the parliament. It need to be passed in that two houses, then it will go to president, and if he signs, it will turn into a law or act. This process also we have taken it from the British Constitution. And procedure established by law is not taken from British, it is being taken from Japan, right? So these are the main features, and we also have the parliamentary privileges. The parliamentary privileges are also being taken from the British Constitution only. The next important constitution, the next important source is the United States Constitution, United States of America. The most important one is the concept of preamble is being taken from United States. Fundamental rights we all knew, which is also called as the Bill of Rights, is being borrowed from the United States. Federal structure of the government, that is the union and the states, is also being taken from United States. The electoral college of president, like how a president need to be elected, that who will be the members to elect the president, that concept also we have taken from the United States. And also regarding the independency of judiciary, or I would say, see, in judiciary need to be independent. Okay, they cannot be influenced, they have to be by themselves. That independency of judiciary is being taken from United States. The concept of judicial review, very, 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 very important. The concept of judicial review is also being the concept is also being taken from United States. Here, let me tell you, there is no definition of judicial review in Indian Constitution, or you don't have any article related to judicial review. However, we just imply the meaning of judicial review under Article 13. Okay, whatever is being mentioned under Article 13, we imply it as a judicial review. But in the Indian Constitution, you don't have any such definition for judicial review. And we have three armed forces. One is being the Army, Navy, and as well as the Air Force. We all knew the chief commander for us here is the president. This concept of the president being the main commander is being taken from United States of America only. And equal protection of law, as I told you, the rule of law is being taken from the British, that is all are equal before law, is being taken from British Constitution. This concept, which is also part of rule of law, that is equal protection under law, is picked up from United States. Okay, so these are the important features from United States. And the next one we have is Canadian Constitution. Canadian Constitution is very easy to remember also. The distribution, we all knew that in India we do have union government, and under that we have many state governments, right? Now, whatever the powers or whatever the jobs the governments are having, that need to be distributed among the union states respectively. And this concept of distributing the powers between the center and the state is being taken from the Canadian Constitution. And in Indian Constitution, the distribution of powers is mentioned under Schedule 7. Again, I repeat, the distribution of powers, like who need to do what, which government need to do what functions, which government is having the power to do which job, is being mentioned under Schedule 7, which we will discuss in this video only. In the Schedule 7, it is being the powers between the central government and state governments are equally distributed. And next, the residual powers. The residual powers are retained by the central government. They are being available to the central government only. And the quasi-federal form of government, which we understood that in the first video, that Indian Constitution exhibits the features of unitary and also the features of federal. Both, it means Indian Constitution is exhibiting both the features of unitary and federal, which we call as the quasi-federal. This combination of exhibiting both the unitary and the federal characteristics is also being taken from Canadian Constitution. The next one, Irish Constitution. Irish Constitution is also very, very important, because the main other key area of Indian Constitution, that is directive principles of state policy, which are nothing but the Constitution will give directions like how a government should function, is mentioned under this directive principles of state policy. And how members to Rajya Sabha, you all knew that Parliament, the definition of Parliament is the President, Lok Sabha and Rajya Sabha. And in this Lok Sabha and Rajya Sabha, you will have members. We call them as MPs, and even the Rajya Sabha are also called as MPs. Now, how you are going to nominate people? Please understand, nominate the people to Rajya Sabha, that is mentioned, nomination of members to Rajya Sabha is mentioned in the Irish Constitution. Please, here I'm not using the word election, I'm using the word nomination. And you have to remember that election and the nomination both are different. A nominated person need not undergo any elections, but an election person need to undergo an election. This is what is different. And the method of electing the president, not the electoral college. Method means the process how to elect the president. That process is also being taken from Irish constitution. French constitution, very 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 important, and for even for every most of the for the whole world, one of the most important constitution is because the concept of republic, republic is like we being independent, we like our head. Republic is nothing but the head of the is happening between the states like Andhra to Telangana, or the Andhra to Tamil Nadu, or Andhra to Kerala. The trade which is happening between these states, the inter-trade, we call it as the inter-trade, is happening is because of the Australian constitution. That freedom to do business means I being an Andhra person, I can sell my goods in Telangana or in Tamil Nadu or in Kerala or in Jammu Kashmir as of now, or in West Bengal. That freedom of trade within the country, for these states is being taken from the Australian constitution. Okay. And the national legislature, in the sense of the union government or the parliament, will be making the laws even sometimes which are out of which are of the federal characteristic also. Means even though those are being given, those powers are being given on certain subjects or certain matter, taken the important concept called as fundamental duties. And we all knew that this fundamental duties, when we adopted the constitution in the 1949, they were not there. The fundamental duties to the constitution were added by 42nd Constitutional Amendment Act 1976, which is this amendment is also called as what? Mini constitution. Through this mini constitution or this 42nd CA 1976 only, the concept of fundamental duties have been adopted or have been mentioned in the constitution. Okay. And also a planning commission, the concept of planning commission is also being the concept of planning commission or setting up the planning commission is also being taken from United States, the USSR. The only difference between the Indian fundamental duties and the United States, USSR fundamental duties is here in Russia, the fundamental duties are mandatory, means the citizens are have the mandate to follow the fundamental duties. Whereas in India, the fundamental duties are not mandatory, they are voluntary only. Means you can either follow the fundamental duties or you may not follow. It depends upon your concerns. You have the right not follow also. That voluntary thing is the speciality or the difference. We have picked up the concept of duties from Russia, but we didn't follow. We didn't follow like Russia of making it compulsory for the citizens. South Africa. South Africa, we feel that South Africa is very much behind than India and all, but it is not like that. See, you can understand by this that we have borrowed some of the features from this South African constitution also. South African constitution, we have adopted the procedure for amending the constitution. See, 1949, we have signed up the Indian constitution, and 2020, and in 2040, or if needed in 2050, you want to change the book, you want to bring the changes. When I say changes, it can be either by adding something new or by deleting which is existing. Okay. This changes of this process of changing the constitution either by addition or omission is this concept is being taken from the South Africa. The South Africa constitution, in that they have the process like how to amend the constitution. That process or that procedure of amending the constitution we have borrowed from South Africa, and how the Rajya Sabha members elections should happen is also from South Africa. Again, I repeat, in the parliament we do have two types of members. One is members and the other one is nominated members. From South Africa, how you are going to elect the Rajya Sabha members, that process is being borrowed. Germany, easy to remember. From the German constitution, the first and foremost thing is the fundamental rights, which we call as soul of Indian constitution. You need to understand that they are not absolute. When I say not absolute, means they are not 100% available. Means how can you say they are not absolute is because the fundamental rights can be suspended in case of emergency. So when an emergency is declared, automatically by default the fundamental rights would be suspended. This is one thing. And also the power to declare emergency, like yes, we are the from today onwards a national emergency is going to be declared. Okay, who is having that power to declare? Is the president will declare. When I say president, you have to understand it is the union government. So union government is enjoying that power to declare the emergency in the country. And the union government enjoying this feature or the power to declare emergency given to the union is from the Constitution of Germany. From Russia, the fundamental duties and the idea of social, economic, and political justice and in the preamble are also taken. Very, very important, which we will discuss in the preamble. And from the Constitution of Japan, we have taken up the process, the procedure established by law. Very, very, beautifully mentioned, highlighted also. Procedure established by law. What do you mean by this procedure established by law? See, there is an act. Let's suppose, let's take a domestic violence act. According to this domestic violence act, a man, he can be charged, with the domestic violence. And to charge that, they need a process. What is that process? Is the girl or the woman, she will go to the nearest police station. She will file a complaint. Okay, and the person will be called off. This man will be called to the police station. They'll give a counseling, and if it is not set in the counseling, then they will go for FIR. Then they will take him to court. In the court also, it's in the counseling, and then it now this process, uh, I mean, this process, how things need to function, how things need to act. That process, the concept of this process is being taken from Japan. So any procedure established by law, whatever the procedure is being established by law, will establish a process. And this concept of, the phrase called as a procedure established by law is being taken from the Japan Constitution. Please, this is very, 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 very important because this is going to be a very big game changer in Article 21, that is right to life and liberty. So please keep this in mind. The word procedure established by law means the process that is being set up according to the law is what? Again, I repeat. Procedure established by law means the process that is being set up according to the law is called, right? And you are supposed to respect that process being set up according to the law. Okay, you are not asked to break, you are not supposed to break that process. Whatever you do, you have to do within that system only, within that process only, or you call that framework. We call this word as a framework. And this feature we have borrowed from the Constitution of Japan. Right. So by all this, by observing all this, what you need to understand that is Indian Constitution is called as ransacking of many constitutions. It is called as what? Ransacking of many other constitutions. Indian Constitution is called as ransacking of other constitutions. Okay. Because so many features we have taken and made a new constitution called as Indian Constitution. Now, this Indian Constitution, we have we do have 395 articles. You have to understand that in Indian Constitution, we do have 395 articles, and these 395 articles are like do's and don'ts. These 395 articles are divided into groups. Okay, groups. Like let's suppose Article 1 to 4 means 4 articles. It is a group. Now that group you call it as what? Nothing but parts. So what are parts? Parts are nothing but group of articles. You can see part 1, 1 to 4, 4 articles. Combination of 4 articles is part 1. 5 to 11. Okay, 6 articles are combination of part 2. So group of articles, the articles are divided into groups, and that groups are nothing but called as parts, and we do have like that 22 parts. Now, I'll give you And also we do have in the constitution, when we adopted the constitution in 1949, we had only 8 schedules. We had only 8 schedules. Now what do you mean by this schedule? For example, when you open the book constitution, let's suppose under article 1, it is mentioned that India, that is Bharat, a union of states. India, that is Bharat, a union of states. When I say Bharat, a union of states, you need to know the list of the states. The names of the states will not be mentioned in Article 1. Please remember, the list of the states will not be mentioned in Article 1. Instead, it will be mentioned somewhere separately in an area called as schedule, under schedule 1, where the list of the state names will be written in alphabetical order. So you will have here one dot or one star, like it's like bibliography. In your textbooks, you'll have one, two, three on the words. They will write 1, 2, 3 and all. When you refer the last page, you will see what do you mean by 1, 2, 3 and all. Likewise, schedules are something which are not explained in the articles, but they are explained separately. Now, likewise, we do have how many? Initially, when we adopted the constitution, we had 8 schedules, but afterwards, another 4 more schedules were added. Let's see what are those schedules. The schedule 1, again, this is very, very important. The schedule 1 is a place where you will have the list of all the states and union and territories in alphabetical order. So whenever a new state is formed or created, or whenever a new UT is created, the name will be added immediately here. Okay. Schedule 2 mentions about the salaries, the powers given to president. What are the powers? See, in the article it will be written that the president is having powers. Now what are those powers in detail will be mentioned in the schedule 2. So the salaries, powers of president, the governor, speakers, deputy speakers of Rajya Sabha and Lok Sabha, and about the Supreme Court judges, High Court judges is mentioned in schedule 2. Schedule 3 makes you to understand about who will take the oath, what is the process of taking the oath, and what is the text you have to read in this oath is mentioned under schedule 3. And schedule 4, very, very important. Whenever a new state is formed, obviously schedule 4 also will change, because the representatives also will change, right? So you have to bring the representatives from that particular new state also. So schedule 4, the Rajya Sabha members, how many members need to represent the states and the union territories will be mentioned in schedule 4. Schedule 5, very, very, very important. Schedule 5, schedule 6, very, very important is the schedule 5 and the schedule 6 talks about the administration of scheduled areas and scheduled tribes. See, we knew that the most vulnerable sections of the society, the Indian society, are the scheduled population, that is the scheduled SCs and STs. How you are going to administer, how you are going to in some areas, like we'll have more and more tribal population, some areas will have more and more SC population. So how you are going to handle them, that is what is being mentioned under this schedule 5 and schedule 6. The next one, schedule 7. What is this schedule 7? This is what I was talking, this concept. This schedule 7 is only mentioning about the distribution of powers between the union and state government and the concurrent list. So whatever the powers are there between the center, state, and the concurrent list, who all need to do what functions is being mentioned under schedule 7. Schedule 8, is about official languages. See, as of now, today we do have 22 languages, but when we adopted the constitution, we had only 14 languages. Okay, and from 1961 onwards, we had new languages being included separately. I will explain again that also. Okay, or I'll explain here. This is what is about schedule 8, so don't get confused. So what are the new languages added in schedule 8? 1961, by 21st CAA, 21st Constitutional Amendment Act 1961, apart from 14 languages, the 15th language called as Sindhi is added. Sindhi, the 15th language, has been added. 1992, by 71st Constitutional Amendment Act, we had 3 languages being added. One is Konkani, Manipuri, and Nepali. See, we have given recognition to Nepali language in our constitution, and today we are suffering. When our relations with the Nepal are declining and going down. Okay, and also in 2003, by 92nd CAA, we had four more languages being added. That is Bodo, Dogri, Santali, and Ithali. These are the areas near Bihar and all. Okay, so these languages are being added. So in Schedule 8, when we adopted the constitution, we had 14 languages. But from 1961, we have 15, 16, 17, 18, 19, 20, 21, 22. 22 languages are being added. And as of now, today in Schedule 8, we have 22 languages. So officially, the Indian constitution officially recognizes 22 languages of India, right? And the Schedule 8. The Schedule 8 is the most popular and the most controversial kid in all this schedules. He is the center of attraction kind of guy, and we'll anyways discuss this Schedule 9. When we adopted the constitution, was not there. It was later adopted by first Constitutional Amendment Act 1951. So Schedule 9 was adopted by first Constitutional Amendment Act 1951. Schedule 10, which is also very, very important, was not there in the constitution initially. It was later adopted by 52nd CAA 1985. And in Schedule 10, it would be about the disqualifications. If a person wants to change a party, some people what they do is they are present in a party and they will praise the other party. Let's suppose there are two parties X and Y. Now I am member of X but I will be praising continuously the party Y. Now it is against the spirit of X, right? And people have chosen me from X because I am against Y, but I am actually praising Y. This is against the party thing. So I should be disqualified. And how I will be disqualified? What is the process of disqualifying? Who is the ultimate power for disqualification? It is all being mentioned under Schedule 10, which is also called as anti-defection. Anti-defection law. Schedule 11. When the constitution was adopted, it was not there. It was added later, and it was added later by 73rd Constitutional Amendment Act 1992. Charmer, very important because the 11th schedule talks about the responsibilities and powers of panchayats. Schedule 12, we have 74th Constitutional Amendment Act 1992 again. Okay, 74th Constitutional Amendment Act 1992. In the Schedule 12, you will have the responsibilities and powers of municipalities. Okay, so these are the 12 schedules mentioned in the Constitution. So as of now today on 2020 June 26th, we have 395 articles plus amendments. You have 22 parts, and we do have 12 schedules. Right, so this is what is the first chapter of our syllabus. The third chapter of our syllabus, that is Salient Features of Indian Constitution. Let me remind you, for those who are attending the class today, the first chapter, that is Evolution of Indian Constitution or Historical Underpinnings of Indian Constitution, we will discuss later. And the second chapter, Making of Indian Constitution, also we will discuss later. We have started off with the third chapter, that is Salient Features of Indian Constitution, which is completed by this point. Now next we are going to discuss about the fourth chapter called as Preamble. So this is the fourth chapter. Very, 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 very important. Preamble is nothing but the foreword. Okay, and this preamble will let us know the essence of the Indian Constitution. Means it is like a gist of Indian Constitution, like what is ultimately, what on a whole, what is the bottom line of Indian constitution is mentioned, is can be clearly depicted from this preamble. And the preamble is called as the foreword, or or you call it as a preface, you also call it as what, preface, and it is a very very important part of the book. And for any book, it's not about just about the Indian constitution. For any book, this preface or forward is considered as the most important part. And this concept of preamble we have borrowed from United States of America. We have discussed this also, that the preamble has been taken from United States. Now let's start the lesson. Before starting off the lesson, this is what you have to understand, that when you open in the Indian Constitution, this is what you will find in the preamble. I'll just read out the text that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, into a socialist, secular, democratic republic, and to secure to all its citizens justice, liberty, equality, fraternity in our constitution on this 26th November 1949, do hereby adopt, enact, and give to ourselves this constitution. So let me explain you here the what are the important keywords. So see here, we, the people of India. You have to understand people. So when I say people, it means both citizens and non-citizens. So the people of India, having resolved themselves to constitute India into, they are ready to change India into a sovereign, socialist, secular, democratic, and republic country. I mean, they want the government of India to be a sovereign government, a socialist government, a secular government, democratic government, republic government, and also they want to secure and they want to ensure that the citizens of this country to have justice, liberty, and they have decided this to be adopted. And with all these characteristics that the government need to be like this, and this is what need to be given to the people on the Constituent Assembly, which was conducted on 26th November 1949, they have adopted, enacted, and give themselves to the Constitution. Means they are giving themselves to the Constitution. They are following by the Constitution. So please understand that this is not the original constitution, because in the original constitution you will not see the word sovereign, I mean, you will not see the word socialist, secular, in the original constitution. You will see only the sovereign, democratic, and republic in the original constitution. So let's discuss about this now. Right now, when you see this constitution, when you see this preamble, the first and foremost thing is you have to understand what is the source of preamble. What is the source? So we know the concept of this preamble is being taken by United States. Okay, the spirit is taken from United States. But what is the actual source of preamble? Is we do have three sources. One is objective resolution. We do have three sources. Here we do have three sources. The first one being the objective resolution. The objective resolution is being proposed by Jawaharlal Nehru. Okay, and it was declared by Jawaharlal Nehru on 13th September 1946, and it is adopted in the Constituent Assembly on 22nd January 1947. What is this objective resolution? The objective resolution is nothing but explaining the purpose of declaring constitution. Means why we need constitution. This is what is being declared under this objective resolution. So this is being declared, the need of having the constitution is being declared by Jawaharlal Nehru on 13th September 1946, and we have adopted in it on 22nd January 1947. The second major source for the preamble is French constitution, because in the French constitution only we have the words liberty. The word liberty the word equality and the word fraternity and the word republic here are being borrowed from the French Constitution. So what have been taken from French is liberty, equality, fraternity, and republic. These four concepts have been borrowed from the French Constitution. And the third major source for the preamble is the Russian Constitution. How can you say Russian Constitution is? When we are talking about justice, the word justice and the type of justice, like social justice, economic justice, and political justice. We have social, economic, and political justice. Liberty is being ensured. When I say liberty, liberty of thought, okay, thought, I have the freedom to think. Not just thinking, I have the freedom to express. I have the liberty to believe what I believe in. I have the liberty to have faith on something and worship something. So the citizens, so the preamble, when you look after the preamble, you will understand what the preamble or the constitution is ensuring for the citizens. So constitution is ensuring to the citizens the justice, liberty, that is liberty of thought, expression, belief, faith, and faith and worship. And the third one, the other third feature which is being ensured to the people is equality. And what kind of an equality is about status, ensuring equality in status and ensuring equality in giving opportunities everyone. That is the reason Article 16 of the Indian Constitution says that the government need to give equal opportunities with respect to the people in public jobs, or when I say government jobs. Okay, so Article 16 states that according to Article, to give equal opportunities to the people in the matters of public jobs. In the government jobs, everyone should be treated equal, not the private ones. So regarding the public jobs, all need to be treated equal. This is what you'll find it out in the word when you see the preamble text, equality. And fraternity, it's nothing but ensuring dignity of the individual and as well as the country also. We need to ensure the dignity of the people as well as the integrity of the nation. We have to ensure that the country is also integrated. The next one. When you see this preamble and when you see these words, sovereign, socialist, secular, democratic, and republic, these are the key words or ideals of state, means how a government need to follow. When I use the word state, you have to understand here government. Okay, here in this context. Okay, ideals of state is nothing but government, how the government need to function. The government is expected to be sovereign. Sovereign in the sense is expected to be independent. We will no longer follow the orders of any other country. Means British can no longer control us. Whatever it is our independent. We are independent decision makers. We will not abide by the laws of the British Parliament. This is what is being called as sovereign. Socialist will make sure that all the natural resources are distributed to people equally. All the natural resources are distributed to the people equally. This is nothing but called as socialist. The third one is being secular, where the church will not interfere in the matters of the government. The church will not interfere in the matters of the government. This is nothing but being secular. And please understand this concept of secular. See, initially it was not there in the constitution. It was not there in the constitution. But when the preamble was amended according to 42nd CA 1976, this word is being added in the constitution. See, initially the constitutional framers thought that there is no point of adding secular, because we always have that religious tolerance. They don't want it to be specific, but they want to make it more and more authentic. That's the reason the word secular is being incorporated in the constitution. Okay, and what kind of how we are being secular is by equality, by ensuring equality of religion, and no religion enjoys special status, and states, when I say states in the sense of government, will not have no official religion. This is what is expected under being secular. And here, I want to ask you a question. This is very, very important. Enumerate secularism in Indian Constitution. Enumerate means list out how secularism is ensured is in the Indian Constitution. I'll just write down Article 14, and anyways I'll explain in the class, but just for your information. Article 15, Article 16, 25 to 28, 44, 325 to 326. That is right to vote. Okay. Article 44 is Common Civil Code. 25 to 28 is right to religious freedom. Means state equal opportunities in matters of public jobs. State in treating equally irrespective of their caste and religion. And Article 14, equality before law. All depicts secularism in India. Apart from that, constitutional secularism. Also, we do have. According to Article 58, any person can contest for post. Article 76, anyone can become Attorney General. Article 165, anyone can become Advocate General. 124, anyone can become Supreme Court Judge. 217, anyone can become High Court Judge. 233, anyone can become District Court Judge. 148, any person can be a CAG, that is Comptroller and Auditor General. 50, yeah. 324, any person can become the Chairman of Election Commission. All this shows all these articles, right from Article 14 to Article 324, depict how secularism is followed in India and how Government of India is ensuring ensuring this word secular. It is ensuring this word secular, right? The next one. Democratic. Democratic government means the government which is by people, for people, of people. Okay. In India, we have democracy in an indirect manner. How is by parliamentary form of democracy? How can you say it as indirect? How? These people, they will appoint their representatives. Now these representatives, they form, they control, and they remove the government. So people are not directly doing it. Instead, people are doing it through their representatives, and so you call it as indirect democracy. And how you can find out how we can ensure democracy is by Article 325 and Article 326, where you have right to vote for both MPs and MLAs. Okay, so this word is democratic. Next, I hope you understood. I'm trying to explain each and every keyword is mentioned in the preamble. Republic. Yes. Let's compare India and UK. The head of nation, head of government. The head of nation in India is the president, and here in UK it is Queen. The president is elected one, is the elected head. The elected head of nation, whereas Queen is monarchical. Okay. The head of the government for India is the Prime Minister, and for UK also Prime Minister. This Prime Minister is elected for us, and for them also we have elected. Why do we call India as a republic is because the head of the nation is an elected head and not a monarchical head. That's why we call it as a republic nation. India is a republic nation because our head of the country is elected, but not family legacy. It is not a monarchy, right? So these are the major keywords, and you also have the other word, unity and integrity. The other word, unity and integrity, you can see. I'll ensure. I'll rub this in. Unitary and integrity of the nation. It means how you can find out this unity of integrity of nation is under Article 1, where the state is being defined. The state is in the census country is defined. That is India, that is Bharat, a union of states, a union of states. So Article 1 talking about definition of state, which shows us the unity and integrity of the nation as mentioned in the preamble. Right? Now, so the question is, and here I would like to also mention one more word. Assuring. The fraternity is nothing but ensuring brotherhood and assuring individual dignity. What do you mean by individual dignity? How you are going to ensure individual dignity? You are going to ensure individual dignity by Article 17, which talks about prohibition of untouchability. See, you cannot practice untouchability. Okay, if you're practicing untouchability means you don't give dignity to an individual, you don't respect that individual. So the government, the Indian Constitution has mentioned about the prohibition of untouchability, which was a very big social taboo for so many years. That was also handled in the Constitution under Article 17, where we speak about prohibition of untouchability. And also the other way to ensure individual dignity is through Article 23, which prohibits forced labor, you know, yogini system, prostitution, human trafficking, beggary, etc. So you have to understand, see, it's not just a simple word. How you are going to ensure the dignity of the individual is by implementing Article 17 and by executing Article 23. Article 17, which talks about prohibition of untouchability, star mark, very, 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 very important. And Article 23, which speaks about the prohibition of forced labor, Jogini system or Devadasa system, a prostitution system, the human trafficking. Human trafficking. I'm not talking about women trafficking. We are talking about human trafficking. We are talking about human trafficking and also about beggary and prohibition of beggary is all being ensured under Article 23. Now, the question is, so you understood that when we see the preamble, you will get to know what is mentioned in the Constitution, right? Now, the question is the most important segment. Is preamble a part of constitution? Is preamble a part of constitution? See, we are saying that preamble is giving us the gist of the constitution. It is talking about what constitution promises is being mentioned. Is preamble a part of constitution? Now, you have two options. Either you have to go with yes or no, right? You just can't say yes or no. You have to give sufficient evidence. Okay, for this, why you are stating it as as a part of constitution, why you are not stating. So let's start it off. So this debate, whether it is a part of constitution or not, it started off in the year 1960 Perubari case. Okay. In this case, in this particular case, Supreme Court stated that preamble not part of constitution, not part of constitution. Okay. Why? Because see, in this particular case, where Perubari case, West Bengal, at that time in 1960, government of India was ready to hand over some territory, some part of Indian territory to East Pakistan. Okay, then we didn't have Bangladesh. So we were ready to hand over some part of the territory to East Pakistan. Now people criticize like how government can do this, how government can give away the land to East Pakistan. Bolke, people started questioning it, and people started questioning it, and there were numerous debates regarding this. The government said that it is having that sovereignty to do this. The government stated that it is having that sovereignty to give the land to East Pakistan. And it said, and this word sovereignty, you will find it out in the preamble, right? You'll find out this word sovereignty in preamble. In this context, the Supreme Court said that no, you cannot give the land to the East Pakistan like that. You have and the government was saying yes, I can give because the sovereignty is mentioned. I'm sovereign. The government is sovereign. How can you say that government of India is sovereign? Then government of India stated that in preamble you can see the word sovereign. That word sovereign is giving me the strength to take the decision and give the land to East Pakistan. Okay, the government has replied this. Then Supreme Court stated that. Then Supreme Court, standing against the action done by the government, has said that you cannot be called as sovereign because preamble was never part of the constitution. Supreme Court has stated. I hope you understood. So government supported its act of giving away the land to East Pakistan by saying that it claimed the status of being sovereign from the preamble, from the context mentioned in the preamble, that is the word sovereign. And Supreme Court immediately slashed out stated that no, you cannot be sovereign. You cannot be called as sovereign because preamble was never part of the constitution, so you don't have the power to give away land to the other countries. Supreme Court first time in this particular case, Berubari case, has stated that preamble is never part of the constitution. Right? Now, in 1973, case one in the Bharati case. In this particular case, Supreme Court has gone against its previous judgment. Yes, and Supreme Court is having that power to, change its judgment, its stand it has taken in the previous cases also. Has stated that preamble is a part of constitution. Preamble as part of constitution. Okay. Now, how can you say that preamble is part of the constitution? What is the proof? Is 1949, on November 26th, when the Constituent Assembly signed the constitution book, they signed the constitution book with the preamble also, means they accepted that preamble is also part of the constitution, and so they signed the doc. Since they signed the document on preamble is still part of the constitution. See, yes, we can amend the constitution. See, under Article 368, we always have the power. According to Article 368, you can amend the constitution. Constitution can be amended, means constitution can be changed. When I say constitution can be amended under Article 368, In the same process under Article 368, how you are going to change the constitution, in the same way the preamble also can be amended. Again, I repeat, like how constitution is amended under Article 368, how the rest part of the constitution can be amended under Article 368. In the same way, the preamble also can be amended under Article 368. And you can amend the preamble, you can amend the preamble, and it has also been amended once. Till now it has been amended only once we have amended the constitution under Article 42nd CA in 1976, where the words called as socialist, secular, and republic have been added. Sorry, socialist, secular, and integrity have been added to the preamble. So the original text of the preamble is not this, the original one. The words is socialist, secular, and the and integrity have been added on later by 42nd CA in 1976. 1976, right? Now, however, there is one condition that yes, you can amend the preamble, but you cannot amend the preamble, or you cannot amend the preamble disturbing the basic structure. You can amend the preamble in many ways, whatever you want, but you cannot disturb the basic structure of the constitution. Means, see, you can renovate your house the way you want, but you cannot, remove the foundation pillars. The same way, the constitution can be amended, the preamble also can be amended. Whatever you way want, you can change it, but don't disturb the basic structure. This is what was highlighted by Supreme Court in Kesavananda Bharati case. That's the reason Kesavananda Bharati case is called as one of the most prominent cases in the history of Indian Constitution. In this particular Kesavananda Bharati case, only many changes have been incorporated in the Indian Constitution, and it also has propounded a new doctrine called as doctrine of basic structure, where it stated that the constitution can be changed, the preamble can be changed, but you cannot change the basic structure of the constitution. You cannot change the founding principles of the constitution. This is what was stated by Supreme Court. So ultimately, by this lesson, you have to understand that key preamble, as per the Supreme Court's judgment, preamble is a part of constitution, and preamble can be amended like the other parts of the constitution as mentioned in Article 368. That's all for today. So we have completed two chapters. One is Salient Features of Indian Constitution, and the second one is Preamble. In the next class, we will discuss about Article 1 to 4. We will start off the articles, Article 1 to 4, that is Territory of India. If you have any doubts, you want to share feedback, please, you can follow me on my Instagram ID. This is my ID, Archana_ambitious, and you can even share me your feedback also. You can let us know so that we can work much more better. Hope you enjoyed the session. Please go through the Lakshmikant again, do a revision for yourself, and it is very very easy. Trust me, constitution is not so tough. You have to just understand the logics, and you have to you should have that habit of read between the lines. You have to develop that. That's the only point. Hope you enjoyed the session. Thank you so much for giving me this opportunity. Have a great day. Jai Hind.